So, thank you all very much. Morning again. Please be seated. Please call the case.
Good morning, Your Honors. The matter before the court this morning is a case entitled Hier v. Slate Valley Unified School District, case number 24 AP 054. Representing the appellant, Slate Valley Unified School District, is Sean Toohey. Representing the appellee, Curtis Hier, is Andrew Snow. Seated at council table with Attorney Snow is Bill Mew.
Okay. Okay, counsel, come on up. If you would, please identify yourself and your client for the record, and then proceed with your argument.
Thank you, Your Honor.
Thank you.
May it please the court. Sean Toohey for appellant and cross appellant, Slate Valley Unified School District.
Thank you.
Don't be afraid to speak up.
Okay, I'll get a little closer. So how appropriate it is that we're here today in a school building talking about student privacy rights. Decades ago, the U.S. Congress enacted FERPA, which is a guarantee of confidentiality of student records and serves really two purposes. One, it guarantees parents the right to access their records in school, and then two, it requires schools to provide the release of education records to members of the public without parental consent, subject to very specific exceptions. So,
Do we need to even consider FERPA here?
well, in my opinion, I think the Caledonian record case does control this, and in that case, it did say that you don't need to go to FERPA. But I do think in the context of understanding what the student records exemption is under the Public Records Act, you must consider FERPA because it's expressly cited in that exception. So I think it's important to understand that that's the baseline, is that schools under federal law are required to keep student records, education records confidential. And so when we get to the Public Records Act, of course, the question is, does it apply to schools? And absolutely under 317A it does.
So are these actually student records?
Well, our position obviously is that they are not, and I'll get to that. But I think we have to understand what are student records first.
Right.
Well, they clearly involve students, the records.
They clearly involve students, and under the definition set of 317B, it's any record that's produced or acquired by the school district in the course of its business. And of course, that means student records. Student records are produced and acquired by school districts in the course of their business. So they're public records unless they fit under one of the exceptions.
I think you misspoke. You said they were not student records.
Well, what I'm saying is that only looking at 317B, if records that are produced or acquired by a school district are public records, that includes everything.
So
It's under the exemption, so that's why I'm getting to 317C, which expressly states that student records are exempt from the public.
So maybe you could help us if you were to tell us what the purpose of maintaining these records is. What, from your point of view, what is the purpose of it? What's the policy behind it?
Well, what I would say is my first position is that we don't really look at the purpose of records. We determine whether they are public or not. If they're public, we release them, and if they're not, if they fall under the exceptions, then and I think that's what Caledonian record gets to, is that if it's a student record, that's a broad and unqualified exemption. We don't look what type of student record it is. Is it an academic, a disciplinary, or restraint? We just call it. We see it's a student record and it's an exempt record. And so it's kind of an unusual thing to look at what's the purpose, but I'll get to the purpose of the record, because the purpose, as it's stated in the Rule 4500, is to deal with student safety, among other things.
Well, I assume it's accountability in some way, in some measure, right?
By that argument, I would suggest that there's all sorts of measures under the State Board of Education regulations and the statutes of the Title 16 that deal with accountability for school districts.
But the detail that 4500 requires is for accountability, as the chief just stated. Make sure that it's being done correctly.
It's a document that documents an incident involving a student in a school district. It involves their name, their gender, their classroom. It identifies their teacher, the people who are involved in the incident. Now, if we look at the specific reasons for a restraint under Rule 45.1, it says that the person doing the restraint must consider the chronological and developmental age of the student's behavior, the physical size of the student, the gender of the student, any known physical, medical, or emotional, psychological issues, including history such as abuse history for the student. So these are all very specific things about students, the particular student involved in the restraint. These are preliminary documents that chronicle an incident involving a student at school, and so therefore they're student records. And now when we get to the question of accountability, there's a whole process baked into Rule 4500 that is a complaint process. And part of the process under Rule 4500 requires notice to parents and administrators in the school. And then even certain types of restraints, it goes up to the superintendent and then the agency of education. So one of the important things is, if we're talking about accountability, and the purpose and why do we maintain these records, part of it is because we maintain them because we provide notice to parents about what's happened with their child, which is exactly in line with what we do under FERPA. We provide information about students to parents. We don't provide it to members of the public. Now, I've said the position all along of the school district is that if there is an investigation into employee misconduct that's performed by the school district, that is not a student record. That's a record about the employee. And in that case, we're dealing with other exceptions, but we're not dealing with student records anymore. We're talking about a very specific form that details an incident in a school involving a student. It's an education record as defined by FERPA because it contains information directly relating to the student that's maintained by the school. And it's a student record because it's a record that was produced and acquired by the school district in the course of its business, and it involves a student.
So, Mr. Tooley, if there's a pattern of behavior under 4500 use of restraints from one individual, shouldn't the parent be able to at least determine whether or not the school is on notice that this employee was having some issues involving over restraint?
I agree, and that's why there's a complaint process built into Rule 4500, where the parent, first of all, before the complaint purpose, there's a whole notice provision where they're provided the notice that the restraint in fact happened and provided with the form in question. And then there's a process where there's a debriefing meeting with the family and the school and the people involved to process what happened. And then there's a complaint process where either the parent or other people in the school districts can initiate a complaint, and then the school will investigate, and then there's further review by the superintendent as necessary. So there is a whole process where the people who are involved in this incident can review what happened. And so, and then members of the public, I would suggest, could make a public records request about personnel that were involved in incidents of misconduct that may have been investigated through this complaint process. That's different than saying we're going to give this form that details the incident, which includes permissible restraint and seclusion under the rule and under the law. That is a student record that should not be provided to members of the public upon request.
When, maybe you could just help enlighten me, for one, what are permissible, what are the parameters of permissible restraint that could appear in these records?
So all of this information is detailed in the Rule 4500. It's 4502, and there's so of course there's also, it also defines impermissible restraints, and it includes things like mechanical restraint, chemical restraint, other types of restraint that we just say
No.
those are never allowed in school. But there are permissible restraints, and those factor in based on the individual student who's being restrained. If we need to consider things that the school district knows about that student, including whether or not they're on a behavioral plan, on an IEP, or a 504 plan. And these are all things that are chronicled in these Rule 4500 student restraint forms. So all of that information is, so there are permissible restraints because there are situations in school where there's situations involving imminent harm, destructive property, where it may be appropriate for a trained staff person to restrain a student under the circumstances. And that's what the purpose of this form is. That there's a whole other layer of review that comes after this, but we're talking about these specific forms in this case.
All right. Thank you.
Mr. Tui, I want to switch gears here to the cross appeal. You're asking this court to deny the Rule 55 motion to amend the judgment. And is the request on that cross appeal by the appellee, in your mind, asking this, if this court grants it, then it would be causing the school to have to create a record as to the IEP, the 504 plans, any support plans, regardless of the redactions. Is it contrary to what is the policy of the Public Records Act?
I would say two things in response to that. One, yes, to answer your question, I think they're asking the alteration of a record to indicate something different as opposed to providing a record that's not redacted. What I would also say is the issue where the trial court decided that information about whether a student is who has a disability is on a 504 plan, IEP, or behavioral plan could identify the student. And I'm going to reserve some time to address the cross appeal, so I'm going to stop there and get into that. So I think we've addressed some of the questions, and I think at this point, unless there are further questions, I'm going to reserve the remainder of my time for rebuttal.
Okay, thank you very much, counsel. We'll hear from counsel for the appellee. Are you splitting time or no? All right. Please, okay, thank you. Please, if you would, identify yourself and your client and then proceed.
Good morning. May it please the court, Andrew Snow, representing the appellee, Dr. Valley 35.
Thank you.
Good morning, Your Honors. The issue before the court this morning is whether it's Rule 4500 forms, which are filled out by school administrators, school employees, restraint or seclusion on a student.
Mr. Snow, I'm sorry to interrupt you. I'm having difficulty hearing you, so if you could speak more into the microphone or raise it, then I'm sure the audience is having difficulty as well. Thank you.
That's
Good.
yeah.
Yes, thank you.
The question is whether the Rule 4500 forms are exempt student records under the Public Records Act, or whether they are not. And we agree on that, and that's the threshold issue. Our position is that the plain language of 4500, the essential public interest in access to public records, coupled with the public's significant interest in oversight regarding the use of force by school officials on students, all result in Rule 4500 forms being subject to public disclosure and not falling under the student record exemption.
Is that true even if there's no redaction?
No, so I would say yes, Your Honor, but with the caveat of clarification that because it's not a student record, it is subject to redaction, and so that the student identification information is information that should be redacted and not produced even outside of the student record. The Public Records Act creates essentially a blanket protection on anything with student records. Case law is clear. If it's a student record, it's not subject to redaction. It's just not to be produced. Other records may be produced, but they still need, based on the specific content of that record, require redaction.
Can I ask you what your definition of student records is?
Yes. So the definition of student records is it's based on the content of the record. You need to look at the record and determine that is the purpose of this record related to the individualized experience of a student in school, or does it serve another purpose?
And so don't these 4,500 records exactly that, the experience of a student at a school potentially being restrained or secluded? Isn't that exactly what this record is about?
It relates to that, Your Honor, but the record itself is about oversight of the action of the school in imposing that restraint or seclusion. And there's, for dealing with schools, it's impossible for most records not to have some overlap, some information and defense. But the purpose and the regime set up by Rule 4500 in the Agency of Education really focuses on the actions of the school administration, officials, and agents, and how and when they can impose the restraints and seclusions, and what administrators should do when those are.
But Mr.
And
Snow,
my thought is that the school would use those records if they have a student who had to be restrained or secluded, that they would refer to those records when future incidents might happen to make decisions about what worked and what didn't work with this student and what to do going forward. Wouldn't that make it a student record?
They refer to those records when dealing with the student, but I think regulation itself makes it clear that what actually happens with the records is that they get reported to administrators at school. If they meet certain requirements, they go to the superintendent. If they meet certain requirements beyond that, they go to the commissioner of education. And the purpose is to identify whether restraint seclusion is either used in a way that's not permitted by the regulation or is overused. And under those circumstances, the regulation is clear that the agency and the commissioner must decide whether further education is required for the administration and determine essentially approaches to fix that problem. So it's clearly an oversight issue that the forms are focused on. It just also includes student information.
So, Mr. Snow, the fact that the Public Records Act makes an explicit exception for student records, that's for privacy purposes, for the family of the student and the school administration. Wouldn't this be highly protected? Because this is even a next step involving potential issues involving individual education programs, 504 programs, behavioral issues, and the like. Wouldn't that be the most highest level of privacy that someone would be allowed?
Well, that is exactly why that information still must be redacted. We don't argue that any information that could lead to the identification of a specific student is protected information, and that comes under FERPA, not necessarily the PRA. The distinction is PRA deals with student records. FERPA deals with what they call educational records, which is, I would assert, a much broader category, as Attorney Tui was saying. It is any record that includes student information that is generated or in the possession of the school district. What FERPA then does is it recognizes, however, that that's a very broad definition, and within the FERPA regulations, something ceases to be an educational record once that information that can identify the specific student is redacted. And so under FERPA, there is no, so if we were to treat student records like educational records under FERPA, they would, once redacted, they could be produced without violating confidentiality.
So let me get to the same question I asked Mr. Tui regarding the cross appeal. Your request to amend the judgment pursuant to Rule 59 essentially would ask that the court grant your motion so that the information about students' IEP plans, 504 plans, any academic support plans would be disclosed with the redaction of the student's name. I'm troubled by that because I find those plans highly personal. And I think because they are so personalized, which is the purpose, it would easily disclose who the student is. So tell me why I shouldn't be concerned about that.
Well, the concern is entirely valid, and we agree that any details about what type of plan, whether it's even an IEP, another individualized special plan, a 403 plan. To be clear, the 4,500 forms cast a pretty broad net in terms of what we call specialized education plans are. And so simply indicating that one of those, that they're on one of those plans within the whole range of what they could be, goes a long way to reduce that risk. We've also need to keep in mind that what the trial court ordered was production of the records with specifically names and addresses that redacted, the 40 or the specialized education plan redacted, and any other information that is determined to reasonably lead to the student's identification. We haven't gotten any records produced yet, so we don't know if there are other pieces of information that might reasonably be redacted to get it. What we're saying is specifically just indicating whether they're on any one of these several potential plans doesn't create that significant of a risk.
Mike, I have another concern, which is if we agree with your position here, how does a principal or a superintendent or the person who looks at records and makes a decision as to whether to provide them under a records request, what does one of these individuals do now? If we agreed with your position, they look at a record, it has a student name on it, what's the test? I mean, what do they apply to? What kind of decisions do they apply to this document in order to decide whether to release it or not? And isn't that going to be inconsistent and unworkable?
No more so than, under almost any request under the Public Records Act, Your Honor. Whenever any member of the public requests a record from an agency, school or any other agency, the official at the agency tasked with responding and reviewing that request needs to decide what's responsive to that request, what exemptions apply, and what material to produce. For student records, for records from schools, they can determine that it is a student record, and they can position that it's exempt. They can determine specific information within the record, such as students' names, addresses, those types of things, need to be redacted because they could reasonably be the student's identity and then produce the record. But it's, I guess I'm saying there's no easy way around that analysis, but it would need to occur under any request for any record from a school.
But shouldn't we be concerned about inconsistent results after an examination of whether it should or should not be disclosed? One school district says, we're going to disclose it. One school district says, we're not going to disclose it. That's not a good place to be, is it?
No, but it's an unfortunate, I think, reality when you're dealing with different districts and different people. Like I said, every agency or officials in any agency, when they get a public records request, there's a level of personal discretion, determination, and it's up to the parties involved in that request, and ultimately, if there's not an agreement involving the courts, to find out what is required for disclosure. And I will happily say that there's no magic way to avoid that. But
Except to hold that they're student records.
to hold it something the student record would avoid in that specific situation, having to analyze what could be disclosed, but it would also lead to an overbroad protection where specific records like these, Rule 4500 forms, which exist to monitor and oversee the use of force and restraints and seclusion, form of restraints and seclusion on students, would not be available. And we assert that that's contrary to the purpose and policy of the Public Records Act, which says that there is a strong and inherent benefit to the public to have transparency, specifically for the oversight of government agencies. And I would argue there's few interests that important as ensuring that our students are not being overly subject to impermissible or inappropriate restraint seclusion.
But even with the Public Records Act and the transparency requirements for it, there's a very specific exclusion for records, education records.
Sorry, I would clarify the acceptance for student records.
Students' records. I know we've been going back between education and student, but student records are a clear exception to the Public Records Act in Vermont.
Correct, because that's such a strong and very clear distinction. If it falls into the bucket of student records, you don't produce it, even, you don't think about redaction, it's just not to be produced. But that's why it's important not to pass an overly broad definition as to what falls into the category of a student record. If you use the broad definition of the FERPA, which is anything student information created by a school, that would essentially prohibit disclosing or public records requests for any records having to do with the school. So they need to look at the content and the purpose and intent of the specific record to decide whether or not it should be placed in that category as a student record or an administrative record.
Is that what we said in Caledonian Record versus Vermont State Colleges? We didn't say you need to consider the purpose of the record, the content of the record. Is your comment inconsistent with that case?
No, Your Honor, I would actually say that it's entirely consistent with the Caledonia case. What the court said in Caledonia, as I understand it, is that it looked at student disciplinary records. And the question was, in the lower court, whether student records having to do with discipline of the student were to be produced under FERPA or not. And the Supreme Court came and said, you don't even need to look at FERPA. A student disciplinary record is a student record. End of story. You don't look at the content as to whether it relates to the student's grades or the student's discipline. You just, if it is a student record, it is exempt. It did not define what a student record is, though, and did not provide any definition as to what the content of a record is that makes it a student record. It just says you don't look at the content of the record once it's categorized as a student record and say, do we produce it because it has to do with the student's discipline or the student's grades? And I would like to speak briefly to the issue raised by the justice regarding the creation of new records under our cross appeal. I think there's an important distinction to be made between the creation of the new record and alteration of a record merely to produce information that is already in the possession and contained within the record, but is communicated in a way that makes it exempt. For example, the Rule 4500 forms, to the extent they identify the specific IEP, specialized education plan, whatever it is, that's, we agree, protected information, but that's more information. Contained within that information is that a student is on some form of specialized education. And I think the purpose is to create a record that gives the public access to all of the non-exempt information in the agency's possession without disclosing exempt information. And so in our brief, we cite several cases from out of state that show that the real difference between altering a record to identify non-exempt information that may be buried within exempt information versus creating a new record. And I thank you for your time this morning. Thank you, Your Honor.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 4 minutes and 58 seconds remaining.
Counsel?
Thank you, Your Honor. So I think I want to just touch on a few points that we kind of went over in speaking with counsel. Schools do need a bright line in order to be able to administer this. And the reality is that they have one. Student records are exempt. They're exempt and they can only, and what it says in there, and there's a proviso that says, provided, however, they can be requested through FERPA and released under the provisions of FERPA. And we understand that language, provided, however, because it's used throughout the Public Records Act. It's used in the personal documents section. So personal documents used to evaluate and hire people are not public records under that exception, of course, subject to balancing, which is not applicable to student records. But that section also says, provided, however, the personnel file must be made available to the employee and or herself. That's exactly what this section 11 does. Records are not available, provided, however, they're available to parents under FERPA, or they may be available subject to the other methods under FERPA that provide for students, schools to release student education records without parental consent. And when we look at those protections, one of those is that a person can request education records through a subpoena. And under the regulations 9931 concerning FERPA, if a school receives a subpoena, they have to notify the parents so that the parents, if they so choose, can try to quash the subpoena. And then, of course, if there's a court order, the school can release student records. But those are much different circumstances than what we're dealing with when someone makes a public records request. Also, FERPA has a 45-day response time. The Public Records Act is a 3-day response time. Very different circumstances. So my position, as I said at the outset, I don't think you need to look at FERPA to determine that the student records exemption covers these 4,500 forms. But if we look at FERPA and this concept of de-identifying or redacting under FERPA, it's a much higher standard than anything that we ever have applied under the Public Records Act. And what I'm talking about, again, is under the regulations, again, as 34 CFR 99(3), which defines what it means to talk about personally identifiable information under FERPA. It says the things that the school must consider when it's releasing de-identified records is whether or not a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student could identify the student with reasonable certainty. And then it also says that the information requested by a person, the education agency reasonably knows the identity of the student to whom the education record relates. So, under the Public Records Act, it's very clear, we don't look at the motive of the request, we don't look into it, we just decide, is this a public record or does it fall under a public record exception? That's very different than the process that's used under FERPA when we're talking about de-identified records. And under FERPA, this is the standard, the language is may release. So under the Public Records Act, student records are exempt, except that provided, however, as it says, they may be subject to release under the provisions of FERPA. So that's a FERPA request. It's not a public records request. Wouldn't
that allow for inconsistent results? One school district looking at one thing that's redactable and another school district, another superintendent says, oh, this is okay. And
I think it absolutely would lead to inconsistent results under the Public Records Act. I think under FERPA, that's a whole other analysis, but we're not here really tied to that. I can only say that we have to consider what FERPA requires when we're deciding whether or not something is a student record thing. And our position is that under the Public Records Act, this is these Rule 4500 records are indeed exempt. And so therefore, we would ask you to reverse and grant the school district's motion for summary judgment on the basis that these Rule 4500 forms are exempt. Thank you very much.
Okay, thank you very much. Please call